Hello everyone, welcome to Redbus US channel. In this video, we'll look at the Eagle Act of 2021, which is a House bill that was introduced, basically a couple of days ago on June 1st to remove the per country caps based on country of birth. So we'll look at what it includes, what are the chances of it passing, right? And this is what we'll cover in this video. We'll look at the background and some of the history and all the various aspects that are part of this bill. If you haven't subscribed to our channel, do subscribe for getting regular updates. So the bill called Eagle Act of 2021 is nothing but HR 3648. HR is basically a number assigned when the bill starts in the House, and this is exactly what you see on the congress.gov website. That it is already there, and it was introduced on June 1st. Yeah. And to give you some background of this Eagle Act, this is not something that's new, right? So HR 3648, it's called Equal Access to Green Cards for Legal Employment, a long acronym, and they call it as Eagle Act of 2021. And the whole idea of this is to eliminate per country caps. And it was introduced on June 1st, and it's nothing but a version of the previous HR 1044 and S386 bills that were, heavily, discussed last couple of years, called Fairness for High Skilled Immigrants Act of 2020. And this was introduced by Rep. Zoe Lofgren and Rep. John Curtis. They're the main sponsors of this bill. And it's a big size bill, 35 pages bill. So last time when we had the bill, it was only 7 pages. This time it's a big 35 page bill to start with. And the co-sponsors are about 19 as of June 2nd. So this is exactly what you see on the screenshot is the text of the bill that you can see that says Equal Access to Green Cards for Legal Employment Act of 2021, right? Now let's look at the various aspects of it now. The first one is removing per country caps. I don't have to get into the details, but most of you know this. We have 140k green cards that are allocated every year, and only 7% are given per country, and it doesn't matter the size of the country, right? So essentially, the idea is there is a discrimination based on country of origin, and what this bill aims to do is basically, remove the per country caps. So that's what it says. And also what it does is it increases the per country limits for family sponsored category. And what it means is currently it's at 7%, and it will be increased to 15% for all countries. And it's going to be 2% for dependent areas. These are not really countries, but dependent colonies, those are them, right? So this is the main bill. So what they've done is, as part of the bill, they also given some transition period and putting some rules in place. And this is how it works, right? So, and also the effective date is the first day of second fiscal year. Let's say it passed now, the first fiscal year would be starting from October 1st, 2021. And then the second one would be October 1st, 2022. So that's when it will start, so that's the effective date. And these are the transition rules. When we say transition rules, the whole idea is when we are actually moving away from removing the country caps, they don't want existing rest of the world to be penalized for it. So they're setting aside a percentage of, like visa numbers or green card numbers so that, they get priority here. So as you can see, in the first year, there'll be 30% reserved for rest of the world and 70% for large countries like India and China, right? That's basically open, unreserved, we call them, right? And the second year, it'll be 25%, 30 at 20, and so on and so forth, right? And in the last years, when you go to 7, 8, and 9, it's going to be 5%. So, this is a table. Nothing has changed here. This is what was there in the past, and it's just a replication of what was in the last year's bill. Now, there are also other provisions for the first 9 years. So they're also setting aside a 5.75% for employment-based green cards for rest of the world, right? And the idea is this one is somebody with an approved immigrant petition, but who are actually joining the family or who have not lived in the US, right? So these are additional provisions on top of the transition rules, to support the people who are coming from outside of the country, I would say. And so this is another clause that they added. This has been there in the last year's HR 1044 as well. This is not new. So this is again continuing that. So apart from that, they also continue to have the same transition rules. There are reserved visas. So they put in a restriction that in the rest of the world category, no country can take 25%, right? What it means is, let's say, I don't know, Pakistan or Sri Lanka or I don't know, for example, Burma, any of these countries, or Honduras, right, for that matter, right? So they cannot take more 25% of that reserved visas. Of this reserved in the sense, this is the 30% that they set aside in year one and 25%, right? So that's what they mean by that. So just one country cannot take a majority of it. That's the idea. And in terms of unreserved, which is the 70% or 75% in year two and things like that, no more than 85% can be given to a single country. Means India or China cannot take more than 85%. Yeah, and if anything is left over, then there are no restrictions. So this is the bottom line, right? Now, in terms of they call them occupations of like which are having a demand, high demand, and essentially these are scheduler workers and nurses and physical therapists, and they're setting aside 4,400 visas or green card numbers for that, and not fewer than 4,400. And all it tells is that this 4,400 cannot be taken from the reserved pool. For the first 9 years, right? You cannot take this 4,400 from that, like 30% or that 5.75%. So another important part is that the dependent joining these people are going to get it from an unreserved slot. So for example, if there are 4,400 reserved visas and each of them get 2 dependents, then about 8,800 are taken away from the general pool. So this may sound a small number, but it's actually going to have a huge impact. It may take out a lot of numbers from the unreserved category. Yeah? So it's something to watch out. Yeah? Now, in terms of H1B program, they have done a lot of amendments last year, because this has been a big pain for many of these companies, and Senator Grassley and a lot of these were added as part of the amendment, right? And so they want to strengthen the H1B program and put in some LCAs and LC related rules now, right? We'll quickly summarize them, right? You can read through these in the article. We put a link in the description, but they want to set up a searchable internet database, and the job has to be posted the 30 days. Nowadays, it's not available like that. Now, once this, if this is passed, they want to have a public database for this, and you should include all the basic requirements so that anybody can see. And also, it cannot be advertised as it's only for H1B holders. Yeah. So this is something that is currently done on job postings that tells it's for H4 holders, F1. So you can't do that. It's kind of silly, but many people do that. They need to submit W2 forms, should have the prevailing wage, these are all pretty standard things that are already there, but they're trying to add more clauses. So the big clause is actually the 50-50 rule, which is, I would say, a little bit of a challenge, because the new H1B petition requirement. So if an employer has 50 or more employees and the sum of H1B and L1, they cannot be more than 50% of the total employees. So this is a big clause, right? So this only applies to new applicants. So this is going to really impact all these outsourcing companies. So this could be a problem, actually, but again, also in terms of filing, all the subsidiaries, as long as they file under one entity, they're all classified as one group. So this is actually a big problem, I would say. How they will actually negotiate and lobby this is going to be tricky. In terms of enforcement clauses, they put in like other things. There is no fee. They're going to put some fees in there, and you can't just be one. So all of these are like more enforcement. I'll let you read through these things. They put in some penalties and things like that, right? So I'll let you read through these things in the article. In terms of adjustment of status for I-485, if you have an I-140 approved and it's pending over 2 years, then you don't need to wait for the priority date. Nowadays, of course, the priority dates are moving pretty quickly because of all the challenges with, consulates closing and family numbers moving in, right? But in general, it's a big, long wait. Now, you don't have to wait for this priority date anymore. If you have I-140 pending for 2 years, you can technically apply for adjustment of status, and you can get EAD and also advance parole for this. So this will basically help a lot of people, but it will be uploaded only when the priority date become current and when your number comes in. But of course, it gives you the flexibility to move around and work with a little more flexibility than what you have today. So this was something they put in, and also they address the aging out. Children who qualify for green card, irrespective of the age, they will actually be qualified. So there is no age out situation that we had in the past. And also, if God forbid something wrong happens, the applicant also can qualify the green card if the principal applicant is dead or deceased. And besides that, there are some clauses on I-485. They need to have they need to file this I-485 supplement J, and the EAD will be valid for 3 years. These are all, something that were there from last year. They're all, again, continuing. So these are all not new. Again, some of these, there will be a fees for this and all. I'll let you read through this. We did a video last year as well. It's a pretty long video. I'll let you watch that, and where we go into details of these, right? One important clause is the H4 related H4 EAD ones. So what it says is if you need to have the work authorization, it may not to continue the work authorization. So this is going to be tricky, right? If the H4 EAD is going to be revoked, then you may the H4 EAD will not be there. So at the time of filing, they should be eligible for it. This is what they say. So this one we'll have to see how it pans out. There is also a lawsuit currently going on, so it's not decided yet. We'll see what happens there. Of course, H4 kids are not included anyways. Now, what are the next steps, right? In terms of next steps for HR 368 or Eagle Act, so for is basically it has to go through the committees and then comes to the voting, right? It has to. I mean, it's a long process, but because this bill has been there last year, there is a little bit of support, but a lot of clauses are added, so that's going to change the whole dynamics. So as you can see on the screen, right, this is the big process. It's a pretty lengthy process. Goes from the committees, subcommittees, hearings, calendar, debate, all of these, right? It's a long step. So I will put a link in the description to understand this process. Written a detailed article, and if it passes in the same form, then it goes to president and then becomes a law. So it has a really long way to go. We are in the very, very beginning, so we'll have to see what happens. This is again, it's very, very initial stages. It's not even enough support for this in the house. Yeah. Now, looking at the chances, right? This is a big one that we get asked often, right? What are the chances? So if you look at the co-sponsors, just from a pure number standpoint, there are only 10 co-sponsors for this bill today. In the past, for HR 1044, there were 311 co-sponsors. So that is a big 300, almost 290 difference. So they need to really rally if one gets a lot of support in the next upcoming months. So we'll have to see how this pans out. Yeah, that's going to be critical to get this moving forward. Well, there are many positives, right? Among in this, there are some provisions like 50-50 provision that are not going to be helpful for the bill. There are big lobbies like from outsourcing firms that will actually lobby for at least removing some of those clauses. And again, once it comes back to Senate, again there will be some challenges. So it's not easy. I think the bill in its current form, it's not going to be a cakewalk, right? It has to go through again the hoops. Priority, of course, there are majority of them who continue, but there could be challenges in Senate as well. But one important thing is immigration is a priority for the current administration, so that will help to lobby some of these things. So we'll have to see how these things move. So there will be, I expect this to be a difficult path because the way it stands because of the all these clauses. But there is a priority, so we'll see how it moves. Right? Again, it's going to be because President put in the other bill that didn't make it, so that's why they're trying this route. So let's see how these things move. I will keep you posted on what happens. Do subscribe for getting regular updates. Would love to hear your comments. Please add your thoughts in comments as well. Thank you for watching. Do subscribe for regular updates.